without further ado, let's bring Blake into the show. All right, Blake Beckham from the Beckham Group, Beckham, Beckham -group.com. Blake, welcome to the show.
Michael, good to be here.
All right, thank you for being here. Entrepreneurs and investors in litigation. I wanted to bring you on because most of the time when people come to you, they're in a crisis mode. You help them fix everything. How do they use strategies, efficiencies, and also we'll cover some of the issues about overbilling. Start us off.
Sure. Well, in commercial litigation, you might have a damage case where an entrepreneur owns a company, they have a contract issue with another company, and they're suing for damages. On the other hand, you might have an injunction suit where a company has intellectual property. They have patents, copyrights, trademarks, trade secrets that they're trying to protect. Perhaps they're trying to enforce a covenant not to compete against a key employee that's trying to leave. So if you kind of consider two general areas, one, we're either suing for money or we're being sued, and two, we're trying to change some behavior. Stop using my secrets or my products that you don't have access to.
Big issue.
Sure, and that's a very active area. Certainly, with entrepreneurial business issues, you're going to have a lot of intellectual property litigation. But the one thing that clients should realize is not every case you have to plan to go all the way to trial, and that's what makes people nervous. That's what people worried about, the amount of the bills. But if you have the right team and you have a good strategy and you're efficient, you might have a plan that goes in and tries to capture the other side, slow them down, stop them, and then you work towards a business deal. So every lawsuit doesn't result in a trial. In fact, probably 90% settle short of trial. So you get the right strategy, the right efficiencies, and you make a plan on how to get there without bankrupting yourself.
All right, let's drill down into that. Give me for instance, let's say intellectual property, strategy, efficiency. What is there some kind of a case you've worked on in the past where you can give the audience an example of what we're talking about?
Sure. I just worked on a case for a specialty oil tool manufacturer, and they were in a intellectual property fight with one of the biggest oil field service companies in the world. You know their name. Dick Cheney may bring something to mind.
Got it.
Okay, so there was an injunction fight at the beginning of the case. We wanted to stop them from doing something. They were also trying to stop my client from taking certain acts. And an injunction suit, it's a pitched battle in the beginning.
Right.
There's a lot of depositions. There's document productions. But within 2 months of the initiation of the case, we had a 3-day mini trial, 3-day hearing in front of a judge. And that decision, which we won, sets the tone for the rest of the case. And the rest of the case may never be tried. The client had to spend a lot of money up front, but good lawyers on both sides, the issues are narrowed, the judge is quickly educated because it was an injunction format, meaning that's a hurry up, that's get to this initial hearing in a quick matter. But it was over the protection of intellectual property, and the case was very successful.
All right. Let's talk about efficiencies and how that works with overbilling too.
Sure. Well, one of the biggest pitfalls in litigation is attorneys spending time looking through documents.
Right.
And if a client comes in and says, here's my server and there's my file room, call me in a month when you've read everything.
Oh, that's asking for it.
That's right. And so a client needs to be intimately involved with his attorney. He needs probably to provide some of his personnel to work with the attorneys, almost like a paralegal. But when one of my clients says, I want to help you go through the documents, here's a staff person that can teach you where they are, what to look for, where to find what you need, that's going to be a tremendous efficiency. And then you need to get attorneys that have some technological capacity that when they look at the documents, they look at them once and they summarize them or sort them, because every time you got to go back and touch them, it's a whole new round of money. And that's where people drown, is in all of the paperwork. So do it right in the beginning, spend the money the first time to go through them right, have the client needs to work very closely with the attorneys, working through documents, which would include today emails, text messages, all the different types of electronic documents that there are.
What can people do as a preventative method for being able to prevent these intellectual property issues? We'll cover all these things because you'll be back on a regular basis, but let's just focus on intellectual property. What can you do as preventative medicine so things don't get to that point?
Well, it's going to be in your documentation, and you need a good IP lawyer, a good transactional lawyer that's going to help you with your patents, your trademarks, and something that people don't think about enough is licenses. So, if maybe your patents could be subject to attack, maybe they're not perfect, but if you say, I have these products that I want to license with you, you're substituting the contractual nature of a license for a live or die if this patent is good. So spend some money with the lawyer in the front, get really good contracts, and then more than anything else, stay on top of them, enforce them. If you see a problem coming, get with the litigator early. Don't wait until...
Give me an idea. What does that mean? If you see a problem coming, give us a for instance.
Okay, so if you have a contractual arrangement with another company and the problems are starting to crop up. Now, the dam hasn't broken yet. You're not at war, but you bring in a litigation attorney and you say, I'm concerned in 5 months we're going to have a problem. Well, if the litigator can get involved and say, hey, I think you need to write this email. I think you need to send this certified letter. Hey, your practice over here isn't quite clean enough. Let's clean you up and get you on the right path and document well the problems that your other side said. You're going to have a much more streamlined litigation. You remember the old Fram oil filters commercial? You can pay me now or you can pay me later.
Right.
That's about preparation and being ready for the fight when it eventually gets there.
I got it. All right. We've got about a minute and a half left before we go. Takeaway message from today's lesson: strategies, efficiencies, overbilling. What would you words of wisdom for the audience for people coming?
Well, overbilling.
Okay.
Look, they're not your attorney until you hire them. Right. So negotiate with them. They say their rate is X. See what a discount. Maybe say, hey, I can pay you within a week of every bill. Knock something off. Let's look at a hybrid arrangement. I'll pay you 60% of your hourly rate and give you 20% of the case. But just going in, paying their asking rate right off the bat, perhaps a contingency, perhaps a negative contingency if you're being sued. You could say, they're suing me for $2 million, and for every dollar you knock off of that, I'll pay you something. So there's all sorts of ways to go at billing that's going to help the client. The very best preventative medicine is being very closely involved with your attorney and not expecting the attorney to do all the work. You get in there and get your hands dirty with them.
Perfect. All right. Blake, thanks for being on the show. Appreciate it.
Thanks for having me.
All right. Blake Beckham, founder, president, the Beckham Group, BECKHAM-group.com. We'll be back on the other side of this break with the private equity spotlight and our next guest, Michael Turner. We'll be right back. You've been listening to CEO Money with Michael Yorba. This segment brought to you by the Beckham Group.